My name is Meg York. I'm competitor 18, and I'm arguing for the state. May it please the court. Your honors, we ask that you find the defendant guilty on all 3 charges because the state has met its burden of proof beyond a reasonable doubt. As to the first charge, engaging in animal fighting, the state has met its burden of proof beyond a reasonable doubt on all 3 elements. As to the first element, knowledge, the defendant knows that Goldie obeys his commands. This was evidenced by the fact that when the defendant blew the whistle when the dogs were in the middle of a dog fight, Goldie jumped off Pitt and ran away. Goldie is the defendant's well-trained dog. He commands her. She follows it. And this mens rea element applies to both of these actus reus elements. The second element, conducting the fight. Because the defendant knows that Goldie obeys his whistle, he gave the whistle signal to Goldie, pointed his finger.
Can you slow down a little bit? I'm
yes.
Sorry. Okay.
I apologize. Because the defendant knows that Goldie obeys his whistle, he gave the whistle signal, pointed to Pitt, and Goldie attacked Pitt. And by doing that, the defendant conducted this fight. The third element of this charge is exhibition of an animal fight. In order to satisfy this element, the fight needed to have been a public or private display of combat between 2 animals in which the fighting, killing, maiming, or injuring of animals for amusement or gain is a significant feature.
Ms. York,
yes.
Let's assume that we don't have a videotape, and that's apparently, it was in the possession of the state, so we can't make much of that. Mikey has obviously loathes his father, wants to change his name, has felony convictions, a lot of reasons to distrust him. So why isn't this just, a bad circumstance that happened, and Mr. Elvick used bad judgment, but wasn't planning what evidence is there that he was planning an exhibition and knew somehow that their dogs would encounter each other in a hostile way, because they apparently have been coexisting for months, right?
Absolutely, that is absolutely correct. And that actually speaks to the defendant's conduction of this fight. You're right, the dogs had seen each other. Their yards were separated by a low fence. The dogs could have jumped over the yard. They could have walked around the fence. They never did. They never fought until the defendant instructed the dog to do so. You're right, Mikey Jr. and his father do have a tenuous relationship at best. That being said, that doesn't mean that Mikey Jr. is going to lie about his father's actions on the stand.
He wants to change his own last name. I mean, that's pretty severe, don't you think?
I think Mikey Jr. is 17. But that being said, we have plenty of circumstantial evidence that also speaks to the defendant's committing this crime, not just Mikey Jr.'s testimony. The biggest piece of evidence that we have is the whistle. Because Goldie obeyed the whistle at the worst possible time. She was distracted. She was in the middle of a fight. Still, despite being distracted, despite being in the middle of a fight, she obeyed the defendant's release command. When the defendant gave the first whistle, she obeyed that as well. The defendant pointed at Pitt, blew the whistle, and the defendant conducted this fight.
Let me ask you this, counsel.
Yes.
How do we know that Pitt wasn't the initial aggressor? We know that Pitt came from a fighting house, and we know that he was rendered unfit for adoption, yet was adopted that very day.
That's a good question. While Pitt, yes, he did come from a fighting background, the evidence says that the shelter that housed him was worried about his chances for adoption because people won't adopt those types of dogs. Mrs. Pawson saw Pitt, she saw his temperament, she adopted him. In the 4 months that Pitt has lived with Mrs. Pawson, lived next door to Goldie, Pitt never displayed any signs of aggression toward other dogs, toward animals, toward people. We have you're welcome. We have no evidence that Pitt was aggressive until the defendant commanded Goldie to attack Pitt. So getting back to this last element, exhibition of an animal fight, it is a display of combat between 2 or more animals. We've proven that it's been a display beyond a reasonable doubt. This act was witnessed not only by the defendant and Mikey Jr., but also Mrs. Pawson. Further, we have evidence that the defendant asked Mikey Jr. to bring a video camera with him that morning, suggesting that perhaps the defendant wanted to view this display again or maybe even share the recording. The amusement or gain, we've also established that the dogs were fighting. The defendant was amused by the dogs fighting. This was evidenced by multiple testimonies about the defendant's conduct during the fight. As the dogs were fighting, Mrs. Pawson testifies that she came out and saw the defendant smirking and cheering the dogs on. Mikey Jr., he testified that the defendant was grinning, clenching his teeth, and more revved up than ever before.
Why do we believe Mikey Jr.? He's a convicted felon, and the instructions told us that we have to consider them.
Absolutely, and that is something that you are allowed to consider. That being said, because Mikey Jr.'s testimony is corroborated in this instance by multiple others, by Mrs. Pawson's as far as how the defendant was smirking and cheering the dogs on, by Mr. Hirsch, which was one of the defense's witnesses, Mr. Elvich's longtime hunting buddy. He testified about the behavior that Mikey Jr. said he saw, a fist pump in the air, Mikey Jr. described it as egging the dogs on. Regardless, it was a fist pump in the air. Mr. Hirsch testified about that exact same behavior, and that the defendant does it when he watches Goldie go in for a kill. It is when he's satisfied with her behavior, which indicates that he was satisfied with her behavior in the fight. Of course, even though we've established that the defendant was amused, we also have established that the defendant was amused for a significant period of time as required by the statute. Now, significant simply means that it was of a noticeably large amount. From the moment the fight began until the fight ended, the defendant displayed signs of amusement. He was grinning, smirking, cheering the dogs on, pumping his fist in the air. The defendant displayed signs of amusement for 100% of this fight.
York, isn't that only based on his son's testimony? That there is nobody else, and that so far we haven't heard about Ms. Danger's. You have essentially three witnesses for the state who clearly have a bias. Ms. Pawson, who refers to Pitt as her child, Mr. Elrich, who basically wants to be called something else, and Ms. Danger, who apparently takes as much pride in bagging a hunter as you would claim Mr. Elvick does in bagging a dog. So how do you reconcile that?
So you're correct. We do have, there are potential biases of these witnesses. There's nothing to evidence the fact that these biases are so significant that they would lead people to lie on the witness stand or really change their description of what happened in such a dramatic way that would change the fact that the state has met this burden beyond a reasonable doubt. Mrs. Danger, Officer Danger, yes, she did take pride in what she called nabbing a hunter, but Officer Danger's testimony does not diminish the fact that we have satisfied this beyond a reasonable doubt. She came to the scene late, she was proud in her arrest, but that doesn't change the fact that the defendant engaged in this behavior and engaged in each element enough to satisfy this crime beyond a reasonable doubt. And moving on to the next crime, conspiracy to engage in animal fighting. This charge has two elements, intent and agreement. We have strong circumstantial evidence that the defendant intended to engage in an animal fight. We've satisfied this element beyond a reasonable doubt. On the morning of the fight, the defendant asked Mikey Jr. to do something unusual. He asked him to,
Counselor,
yes.
I'd really like you to address the third charge before we get back to the conspiracy.
Absolutely. The third charge, endangering the welfare of a minor, has two options. The defendant needed to either knowingly and unjustifiably place a minor in danger of imminent harm, or knowingly and unjustifiably induce, cause, or encourage a minor to engage in unlawful behavior.
Do you think that the state has proven both theories or one?
Or do you believe that you need to elect one or the other, or are we just supposed to say, oh, okay, we'll find one or the other?
The state, so I do, because they are connected by the conjunctive or, the state needs only prove one to satisfy its burden of proof beyond a reasonable doubt. We've clearly established that the defendant encouraged a minor to engage in unlawful activity. That being said, yes, the defendant had personal knowledge through his time as a police officer, through his 35 years as a police officer, that he believed that pit bulls were dangerous. He testified about kids' arms getting ripped off. Still, he brought his minor son to the scene of this dogfight. He encouraged Mikey Jr. to the scene, placing him in harm. That being said, we believe that encouraging a minor to engage in unlawful activity is our stronger avenue here, and because either can be proven, we've opted to go with this one in this crime. Okay. So for the knowledge requirement, again, the defendant, like I said, police officer for 35 years, he knows the laws of his state. He knew Goldie and Pitt were fighting. He knew that he blew the attack whistle. He knows that Goldie obeys the whistle. He knows he was amused. He knows the laws of the state. He knows he was engaging in an unlawful activity. Still, despite knowing he was engaging in an unlawful activity, he encouraged his 17-year-old son, Mikey Jr., to participate. He asked Mikey Jr. to film the dogfight and thus encouraged him to engage in an unlawful activity. And finally, with this crime, we must ask whether or not this was justified. The state has proven beyond a reasonable doubt that this was not justifiable behavior. When something...
Sorry, I'm just talking about that. What if we were to believe the testimony of the defendant that he actually asked Mikey to film this just to document what was happening and document that this other dog was attacking his?
That's a very good question. So there's a twofold answer to that question. One is that under the theory that the defendant brought Mikey Jr. to imminent harm, if he's asking Mikey Jr. to film the scene, he didn't, even if he thought the dogs were fighting, he didn't, one, do anything to break up the dog fight until Mrs. Possum came out screaming. Two, he didn't go take the video camera to film for himself. He called his minor son to the scene, calling him to something that he believes is dangerous. Second is that if we believe, the defendant testified that yes, he was filming for evidence of a crime, but that doesn't line up with the circumstantial evidence that we have that says that he knows he was blowing the attack whistle. He knows Goldie obeys his commands. We know he knows, because when he blew the whistle again to call Goldie's release, she immediately jumped off Pitt and ran away.
How do we know that Mikey Jr. heard the whistle when there's been some testimony that it is inaudible to humans?
The whistle does say on the package that it is inaudible to humans. But Annie Gunn, who is the inventor of this Acme 5000 whistle, even she testified that the whistle makes a sound and vibration when it's blown. She has high motivation to uphold her whistle's reputation as inaudible, but even she testifies that it is possible that Mikey Jr. heard the signal. And that also is supported by the fact that Mikey Jr. has been hunting with his dog, or with his dad, for some years. He knows that whistle. He's heard it many times, according to his testimony. And even if we just set that testimony completely aside and said maybe he didn't hear the whistle, we still, again, have strong circumstantial evidence that Goldie obeyed the whistle's commands, because we've seen her obey him in the middle of a fight. So getting back to the third element of the endangering a minor charge, we're talking about justification. The state has proven that this was not justified because the defendant did know that this was an unlawful activity. The defendant did know that this was a harmful situation, and still he brought his son to the scene. So that is he has no reasonable or legitimate reason for calling his son to come videotape what he knows to be an illegal and dangerous dogfight.
Why would he throw away such a fine reputation, having been a police officer, to videotape this dogfight, knowing it's illegal? Knowing it's illegal,
yes. So the defendant, the defendant believed that Goldie could take Pitt. The defendant believed that Pitt was, as you said, he believed he was dangerous. He didn't like Pitt. So when the defendant sent Goldie into attack, he knew that he had control over Goldie. He thought, I can send my dog into attack, I can film, I can give Pitt the bad rap, potentially, and that speaks to the exhibition of an animal fight. We have amusement or gain as a possible option. We've chosen to proceed under the theory that amusement was met our burden of proof beyond a reasonable doubt better. But yes, if the defendant can convince somebody by filming this that Pitt is vicious, he's gotten the gain of getting Pitt out of the neighborhood.
Ms. York, if, for the sake of argument, let's say you were to find your first two counts on the first count, but not that there was an exhibition of an animal fight. Would you concede that the conspiracy charge would then fail by virtue if we found that the third element of the first count could not be held?
If we found that the third element of the first count could not be held, the conspiracy charge would not be conceded, because the conspiracy charge requires an intent and an agreement. It doesn't necessarily require follow-through. So here we do have the evidence of the follow-through, but that wouldn't negate the second charge.
What evidence do you have of the agreement?
We have several pieces of evidence of the agreement. Of course, our strongest piece is the testimony of Mikey Jr., who on the morning of the fight, the defendant said to Mikey Jr., "We're getting that pit today. Are you with me?" Mikey Jr. replied, "Yeah, sure we will." It is not a defense to the crime of conspiracy in our state that the other party lacked the intent to form such an agreement. So even if Mikey Jr. wasn't being serious, we still have the agreement being made. Not only so, but again, getting back to circumstantial evidence, we have circumstantial evidence that the defendant acted upon this agreement. After Mikey Jr. testified that the agreement was made, the very next thing they did, the two of them, Mikey Jr. and the defendant, got the dog, packed up, walked outside with the video camera. The defendant was acting upon the belief that an agreement had been made. When the dog started fighting, the defendant asked Mikey Jr. to videotape. He thought they were in agreement. I'm going to do a really quick recap of all of the charges that we've discussed thus far, just to clarify any potential additional questions that you have. So as we've stated, the prosecution has made its case. We've satisfied our burden of proof beyond a reasonable doubt on each of the three charges in this case: engaging in animal fighting, conspiracy to engage in animal fighting, and endangering the welfare of a minor. We've satisfied our burden of proof beyond a reasonable doubt on the mens rea elements of each charge: knowledge for engaging in animal fighting and endangering the welfare of a minor, and intent for conspiracy to engage in animal fighting. We've also met our burden of proof beyond a reasonable doubt on the actus reus requirements. The defendant blew his whistle, pointed at Pitt, conducting this fight. The defendant engaged in an exhibition of an animal fight as defined in the statute of the laws of our state. The defendant formed an agreement to commit the crime of engaging in animal fighting with his son, Mikey Jr. The defendant encouraged Mikey Jr. to participate in the illegal dogfight by calling him to the scene and asking him to videotape. And the defendant did these things without justification. Because the state has met its burden of proof beyond a reasonable doubt on each and every element and each and every crime charged, we ask that you find the defendant guilty on all counts charged. Thank you.